Warning to visa holders, here are 5 shocking ways you could lose your status. If you're in the US on a temporary visa, whether it's as a tourist, a student, H-1B, whatever it is, I'm going to share with you 5 of the most common mistakes I see people make over and over that can cost them their underlying status. The frustrating part is most of these are completely avoidable. Unfortunately, I see these in my practice regularly. I'm going to walk through all 5 of these so you know exactly what to watch out for and making sure you're keeping the law. Hi, I'm Jake. I'm the head attorney and founder of ImmiVisa Law Group, one of the top-rated immigration firms here in the state of Utah. If you need help with your immigration to the U.S., self-serve plug, there's a link in the description to fill out our pre-qualification form. All right, let's get into it. Disclaimer first to start, this video is for educational and entertainment purposes only. This is not legal advice. If you think any of this may apply to you, please make sure to consult with an attorney directly. All right, issue number 1 is failing to update your address with USCIS. Honestly, this is such a minor thing. So many people blow this off or are completely unaware that you need to do this. If you're a non-immigrant, so you're a temporary visa holder in the US, and you move anywhere else in the country, you are legally required to file Form AR-11 within 10 days of your moving. This is regardless of whether you filed any application with USCIS at all. If you move, you need to let them know. This is particularly important if USCIS sends you a request for evidence, interview notice, or any other documentation pertaining to your immigration case if you have filed an application. Unfortunately, I've seen this many times. Somebody moves, just forgets to update their address, and they miss a critical notice or deadline, and suddenly they're out of status through no faults of their own, except they just didn't file this very simple form. So the Form AR-11, you can access this online. In years past, you used to be able to mail this to USCIS directly. Now they have unfortunately updated their system to be a little more archaic, so you have to file this online. There is a button to do so. You just click file online on the AR-11 form. Please, guys, make sure that you do this if you have moved within 10 days. This is a very easy rule for you to keep. Okay, common mistake number 2 is confusing visa validity with the I-94 record. This is one of the most common sources of confusion that I see in my practice. A lot of people look at their visas and think, hey, I've got 10 years on this. I can stay for 10 years. Unfortunately, that interpretation is not correct, okay? This mistake can trigger unlawful presence, including both the 3 and the 10-year bar, and make you inadmissible in the U.S. after you leave. Keep in mind that the visa is your actual entry document. This is what you use to come inside the U.S. and request entry. It does not tell you how long you can legally stay. That is what the I-94 record is. The I-94 is the arrival departure record. This is what controls your actual authorized stay. So there's 2 ways that you can access this depending on your situation. Number 1, you can go online and literally just Google I-94, look it up in AI, put in your full name, your passport number, and the country in which your passport is from, along with your date of birth. And if Customs and Border Protection has an I-94 record from you, they will produce it. There's a unique number that's associated with your I-94, and it also tells you the visa you used to come in, and it tells you, most importantly, how long you are allowed to stay. The second way is if you are inside the U.S. and you've requested a change of status, then U.S. Citizenship and Immigration Services sends you a form. It's called an I-797 Notice of Action. It's on this green sort of official looking piece of paper. At the bottom of that paper is the I-94 number, and it also has dates of validity there. You should really make sure to keep track of that because that is how long you are able to remain in that status and remain in the U.S. One other point I want to make concerning the I-94 is just because your visa may allow for a maximum period of time does not mean that the Customs and Border Protection officers will actually give you that period. So for example, tourist visas, it's very commonly known that you can be admitted for up to 6 months at one time. So a lot of people come in here, let's say you arrive on January 1st, you expect to be able to stay here until July 1st. However, a lot of times officers won't give you that full period. I've personally seen CBP officers give only 10 days for B1, B2 visa holders. And then by the time they've come to see me and they check their record, they've actually overstayed their visa already. So it's very, very important. As soon as you get here in the States, check your I-94 record. If you need to change it at all, you can contact the CBP office from where you entered if you need to make changes on your I-94. Common mistake number 3 is engaging in unauthorized employment. Okay, one of the top reasons, to be honest, this is probably the most common reason that people lose their status. Many people don't even realize that they are working illegally. I'm going to give you a very common example that I encounter. Let's say you enter the U.S. on a B1, B2 tourist visa, and you are from Brazil, you are doing remote work back for your Brazilian company while you're physically here in the US, okay? The money that you are paid for doing that work goes into your foreign bank account. It never touches the US settle. It's never in any American bank account. And you think there's no harm, no foul, right? Unfortunately, that is wrong. The easiest rule to keep in mind is if you are physically present in the US and you're performing work, even remotely, even if you are paid abroad, Customs and Border Protection or U.S. Citizenship and Immigration Services is going to interpret this as a violation of your temporary status unless you have express authorization to work here. I've seen this same interpretation apply even with business ownership, okay? Even if you're running your own company, if you're making decisions or participating in directing operations or in actual management decisions, U.S. government officials are going to interpret this as unauthorized employment. Now, conversely, passive ownership is generally going to be treated okay. If you merely own an entity in the US and you receive passive distributions, that is generally considered a safe option. Active management is not. Okay, let's talk about how this problem most commonly arises. I'm going to share with you a few of the most common scenarios that I see. Number one is that at the time of your entry, CBP searches your phone at the border or at the port of entry. This is where they see work emails, Slack messages, bank statements, WhatsApp messages, etc., showing earned income in the US. Another one of the most common ways is when you file to change your non-immigrant status. So let's say you've entered as a tourist and you want to apply to be an international student here. You're filing form I-539 with USCIS to change your status here. On that form, you are directly asked if you have worked in the US. If you answer no, you need to be able to answer how you have been supporting yourself financially in the US independent of employment. Another thing to keep in mind is even content creation or passive income can be viewed skeptically, in my opinion or my experience, by CBP or USCIS. Again, just to give you another example, let's say you're here as a tourist and you're a YouTube creator and you are making content here in the US. If you receive funds from that, even if you don't receive funds, if those facts are disclosed to a CBP or USCIS officer, they may interpret that as employment and that could jeopardize your visa. So what is the point of me saying this? If you have any interest in engaging in work or creative endeavors here that could equate to work, get proper work authorization first. File for a change of status, get an EAD. Don't try to work the system. You can find an appropriate visa classification that will help you to meet your goals without you violating your status. All right, common mistake number 4. This may seem self-evident, but it's failing to keep the visa conditions that you've been assigned. Again, that may seem self-explanatory, but different visas have different rules. So if you break the conditions of your specific visa, you can have your visa revoked or have your status revoked and be out of status. I'll give you a common example I see here. I meet with a lot of international students who have F1 visas. So one of the conditions for an F1 student is that you need to maintain a full course load every semester unless you have authorization for your break, right? If you drop below full-time attendance without authorization, or you let your I-20, your enrollment expire without extending it, your designated school official at the school can terminate your SEVIS record. Basically, it means you're out of status. Now, if you're in that situation, reinstatement is possible. You can file an I-539 if you want to do it with USCIS, as long as you do it generally within 120 days. As long as you file an I-129, generally within 5 months, if you have good justification. I've seen this play for those with medical issues, car accidents, serious family emergencies, or where the DSO has made errors themselves, but it's not a guarantee. Now, H-1B visa workers or other temporary visa workers, your maintenance of status is conditional on you keeping the terms and conditions of your employment. So for an H-1B, your status is tied to a specific employer and specific job. If you change your hours materially, your salary changes, you get moved to a different branch or location, a different job title, etc., your employer needs to notify U.S. immigration about these changes. Or if you otherwise fail to follow the application requirements that your employer submitted that you would when you applied, you could lose your status or fail to get it renewed. Now, in this situation, sometimes you can request something called nunc-pro-tunc relief, basically retroactive approval, explaining extraordinary circumstances, but this is entirely at USCIS's discretion. I'm not going to sugarcoat it. I've seen this work on few occasions, but more often than not, this is a losing battle. If you take away nothing else from what I said, if you do not have a work permit or work authorization that lets you work where you want, do not engage in any side gigs. Don't do DoorDash, don't do Uber Eats, no freelance consulting. Remember, if you're on a work visa, it's going to be very employer specific. If you're on an investment visa, you are working for your investment. If you're an international student or a tourist, don't engage in any of these side gigs either. In my experience, moonlighting without this authorization is just going to jeopardize your underlying status. I don't think it's worth the risk. Fifth common mistake that I see, this should come as no surprise, and it is getting in trouble with law enforcement. Yes, even one stupid decision can destroy your visa status here in the US. There are a category of crimes here called crimes involving moral turpitude. In general, these are going to make you inadmissible to the US. Basically, they're going to give you visa problems. It won't allow you to renew your visa, right? This could even jeopardize your permanent residency. There is a petty offense exception where you can have one CIMT with a maximum penalty of a year or less and an actual sentence of 6 months or less. You might qualify essentially for discretionary forgiveness. This is going to apply most commonly for those who are applying for green cards. For temporary visa holders, this same petty offense exception is not going to apply in the same interpretation. I'm going to give you a scenario of a real client of mine who made a stupid decision that ended up jeopardizing his status. Young guy, about 20 years old, from Spain, here legally as an international student. He walks into a Walmart and just decides that he wants an electronic under $100 and just decides to take it and try to walk out with it. Literally says, "Why did you take it? I just wanted it." Again, very stupid decision. He was arrested, received a ticket and a citation for this, and charged with retail theft. In response, the U.S. consulate in Spain canceled his visa, and then he received a notice to appear before the immigration judge for removal proceedings. So his entire international studies here in the U.S. in just his second year of study are completely gone over something worth less than $100. I couldn't believe when he told me why, but such a small decision led to terrible consequences for him. Basic traffic tickets, think speeding, parking tickets, etc. Generally, these are not going to affect your immigration status at all. Now, DUI or reckless driving may, perhaps, but basic traffic tickets are not. Don't be an idiot. Don't let an impulsive decision destroy everything you've worked for. In US, keep the law and protect your status. Guys, I hope this helped. Keep in mind, as I said in the beginning, most of these mistakes are entirely preventable. Stay compliant when in doubt. If you have any concerns or fears, feel free to reach out to me and or consult with another immigration attorney. If this video helped, please feel free to like and subscribe, turn on notifications, all that fun stuff, so that we can continue to bring you good content here related to the U.S. immigration system. Feel free to drop any questions or comments in the chat. I'll try to read them all. And if you guys need anything further, please let me know. All right, till next time.